Swayam Prabha. Digital India. Educated India.
Dear students, we are on jurisprudence and the Indian legal system, and today we will try to understand in this lecture number 16 the sources of law, and the two main sources of law today we will try to understand. One will be the custom and the other will be legislation. What is the importance of understanding about the sources of law? We will try to understand that, because you might be thinking that what is so much interesting about this thing, that what is the source of law, what are the sources of law, why do we understand that? But once you understand that what are the sources of law, you know what, it will give you a clarity where to find the law. There are at many places where you can find the law, but what are those places? That is the thing that we want to understand, because law is diffuse. Where to find this law specifically, that is the main burden on you, that when you are a law student, we have to know that where to find the law. And it is very easy, you see, that if you do not know how to find the law, then it will be difficult for you, but otherwise it will be easy. If you know where to find the law, it will be easy for you in the profession and also when you are a student of your class. How will you find the law? This is the question. What are the sources of law? This is the question, and it is as easy as if you say that where is the place to find the law. Now, how will you understand that? You see that if I ask you the question that if you have to cook something, what will you do? You will go to the kitchen, and then you will have to, suppose if you have to cook rice, then you will have to find where is the rice, where is the water, where is the pan, or where is the pressure cooker. So, you have to locate everything, and then you have to go for a particular cooking method. And you might be knowing that your mom goes to the kitchen, and then she can bring something very quickly, because she knows where is every item of the kitchen is placed. Likewise, to find the law, if you understand that where to find the law, then it will be very easy for you in the profession also and in your classroom also. So, finding the law is today's task. In this lecture, we will understand that where to find the law. Now, before that, we will also look at the thing that what is the distinction between the origin of law and the source of law. Normally, we confuse by saying that this is the origin of law, and when I ask you the source of law, you will sometimes go upon to the origin of law, and this happens with my students. When I ask this question to my students that what is the source of law, they will say that the source of law may be in the ancient times, maybe in the Dharma Shastras or in the Niti Shastras or in the Vyavhar Shastras, but they will not say that where is the law which is today important, where can we find the law today. So, they could not tell this, and sometimes they will say that yes, the laws, the source of law is in the Vedas, in the Smritis, or in the Qurans, or in the Bible, but this is not the fact. This is like asking you the question that where from the electricity comes, and then you will say that, suppose if I ask you what is the source of this electricity, you will say that the electricity comes from the coal, or you may say that the thermal power plant, from there the electricity comes, but that is not the source of the electricity. That is the origin of electricity, where from originally it is being derived, but the source of electricity may be there in the building itself, from the local power plant itself, or from the local transmission unit itself. So, where easily you can go and switch on, and then you will say this is the source. If you are in a room, you suppose someone will ask you what is the source of electricity, you just say that there is the switch, you can switch it on, the electricity will be on. Likewise, it is important to know where is the law, where to find the law, and in that context the source of law is important, because if you are working in the legal system of our country, you must know where to find the law. Although you all will be saying that yeah, it is very easy to find out in the Google, and Google will help you. Now ChatGPT can help, but all these things may pop up several thousand of options. How will you select one option? How do you find that this option is correct? So, this is how you see that the sources of law are very important. It has a lot of importance for you to understand, and therefore, today we will also try to understand the various sources of law. Now, as far as the main sources of law are concerned and the related theories are concerned, we will also understand that the main sources of law are 3 or 4. What are those 3-4 main sources of law? You will find that the first source of law is custom. The second source of law is legislation. The third source of law is judicial precedents, and the fourth source of law is constitution. Now, these are the 4 main sources of law. Many jurists say that these are the formal sources of law. Many jurists will say that these are the substantive sources of law, but simply we can understand that these are the 4 places where you can find the law. When I say legislation, it means that you can find the law in the legislation. What is the meaning of legislation? That we will also try to understand. What is the meaning of custom? Custom is also a category of rules, and those are also important. So, when it comes to source of law, we will have to also look at the custom as the source of law. What is the meaning of custom? We will also try to understand that. Then the third is judicial precedents. Now, this is the very important source that we will try to understand in a different lecture, that how this judicial precedent is working and how is this a source of law in our country. But in this lecture, I will tell you about 2 main sources of law, which is the first is the custom and the second is legislation. Then there are certain theories which are also relevant, although we have discussed about those theories, but let us try to recapitulate so as to have a better understanding of the different sources of law and its importance. For example, if we take the example of custom, then we have the theory of positivism. What is this theory of positivism? What is this theory of analytical school? I hope that you must be remembering in the earlier lectures we had dealt with that, but still what I would tell you that John Austin, who was the proponent of this school, what he was saying? He was saying that the rule is made by the ruler, the command of the sovereign is important, and the sovereign will issue the command that will be binding upon the subjects. Now, this is what is missing here. When we talk of custom, then that is not the command of the sovereign, rather it is the expression of the people's will, it is coming from the bottom. So, there Austin had not tried to go, because Austin was only focusing upon the command of the sovereign. So, it meant that Austin disregarded the importance of custom, because he was a person who represented the colonial India, and in the colonial India or the colonial British Empire, that British Empire could not survive if they could also understand or they could accept the popular will of the persons in the colonies. So, what happened that the analytical school which came up in the 18th century, that did not give due regard to the custom as a source of law. They would only place reliance upon legislation, they will only place reliance upon judicial precedents. Even for Austin, judicial precedents were not that much important as legislation. So, Austin was in a different category, analytical school was in a different category. However, the historical school, as if you remember, we have also discussed about historical school in the previous lectures, but again to give you a refreshing memory, the historical school that was focusing upon the popular consciousness of the people. You remember fox gist? Now, that fox gist, that was the main core example, the core argument of Savigny, who was the main proponent of the historical school. So, Savigny said that it is the popular custom which is important, which is the source of law, and he said that we should not give that much of importance to the legislation. So, in that sense, you will find that custom having the very important source of law, that is there found in one school which is called historical school. But other schools such as the sociological school, they also have not that much regard to custom. But what is the current situation? Whether the current situation is that custom is not a source, the answer is no, the custom is a source of law of our country. Our legal system is recognizing custom as a source of law. And what about legislation? Austin has given lot of focus upon legislation, command of the sovereign. Now, this command is the will of the sovereign, and this will is expressed in the legislation. So, legislation for Austinian, for the analytical school, that was the main source of law, but we should not restrict ourselves by saying that legislation is the only and exclusive source of law. Rather, we should say that there are many sources of law, and 4 sources of law are recognized. First is the custom, the second is legislation, and the third is the constitution, and the fourth is the judicial precedents. Then we will move on to the custom as a source of law. How we can say when is the custom a source of law? Because just saying to the court, when the problem will go to the court, and suppose if a dispute is relating to the custom, you simply cannot say to the court that lordship, this is the custom and therefore it should be a source of law. That is not so. To prove a custom in the court, you need to have some basic understanding that when can we allege that there is a custom. So, what happens that there are certain tests that have to be done, fulfilled, only then custom can be a source of law. What are those things? We should try to understand those basic components of custom. The first is that there must be a practice. If there is no practice, then there cannot be a possibility of custom. So, first of all, there must be a practice, whether at the level of individual or at the level of the society or at the level of a region or at the level of a nation or sometimes maybe at the level of international. But custom must be starting from the practice itself, and when the practice is made for some time and often it is repeated in the similar situations, then it becomes uses. That means that the practice which was there, that has been converted into the usages of the people. People are used to do something and therefore, they are doing it, they are practicing it, that is called uses. And thereafter, the third thing is that there is a time element. If you say that this is this particular practice is a custom, it means that this practice has been observed for at least 20 long years. It is not that you will say that okay, yesterday a practice was born, and suppose in the meanwhile there have been 3-4 instances of the practice in the same situation, that will become custom. Till now this has not been recognized by the courts of our country, and therefore safely we can say that there is a time element, and that time element is as long as 20 years, which is not a very short span of time. However, many people they say that the test of a custom or the practice should be time immemorial. Now, this time immemorial is very difficult, and as we all know that we are in an age where the modes of communication, the liberalization and the fast mode of transport, that has made possible to move further in a very fast way, and therefore, we can't say that a practice which must be existing at the time immemorial, that will be the practice which will be considered as the source of law. So, we should say that the practice in our country has been, and the court's practice in fact has been, that the time element should be there, but it should not be more than 20 years, or if it is more than 20 years, it should not be time immemorial. The next thing about custom is that a practice must be reasonable. It should not be unreasonable. If a practice is unreasonable, perhaps it will not be sustainable, and maybe that the practice will be thrown away, but sometimes it has been seen that a practice which is unreasonable also, that is alleged, and that is also coming to the court, and sometimes the parties allege that this is also a custom. For example, the right of pasturage over land of another. Now, this has been considered as a practice which is a custom, but in a case where the right of pasturage over the land of another was considered unreasonable, where it completely deprived the owner of his rights to the land. So, suppose if there has been a practice that okay, if the land is vacant and the grass or some fodder is there, then there can be a possibility of allowing any others cattle to come and have a pasture. But if the landowners rights are completely deprived, if everyone will go and feed the cattle there, the right of pasturage of others, that will not be allowed, because that becomes unreasonable. So, even if a practice may be a kind of uses, but still it will not become a custom if it is unreasonable. Likewise, there must be enjoyment of a particular practice as a matter of right, meant that there was no dispute regarding the enjoyment of a particular thing. So, for example, if you say that this is the place where I live and I have been living there, although I do not have any documentary proof, then in that case it will be only allowed if you can show that you are living there without harming others' rights, without anyone else raising objection onto your stay there, then only you can say that this is you are enjoying something which is peaceful enjoyment of a particular land or particular property or even a particular right. So, this can be also there. The next important element of custom is that a practice in question must not be immoral. It must not be opposed to public policy. So, there may be sometimes a practice which may be there, but those can be considered as immoral. For example, there was a case in which a dancing girl was adopted, and in that case it was held that if you allow such dancing girl to be adopted, that may give rise to the immoral trafficking, or maybe that prostitution, that will be also encouraged. Likewise, permitting a woman to desert her husband at will and marrying again without the husband's consent, that has also been held to be opposed to morality. So, immorality or opposed to public policy, that should also not be there. If a practice is opposed to public policy, that practice will not be considered as a source of law. And then the practice concerned should not be in conflict with a statutory law. If a practice which has been a practice for a very long time, but it has been overruled by the legislation, or if it is the fact that a law has come up on the particular practice which is in direct conflict with the custom, then in that case, however long a practice might have been, still the statute will prevail. And I give the example of the students' elections in the universities where the democracy prevails, where there is a general election in the university of the students and they elect their own representative. I give the example that if there are, suppose if the constitution of a student union election that provides for 4 posts, for example, president, vice president, secretary and joint secretary. But what has been happening that in the last 5-6 years, because of the pressure from the students, one more post was added and that was media advisor. So, in the last 5 years, the election officer who was appointed, he allowed, because of students' pressure, he allowed the election of a media advisor and elections were held. Now, after the 5th year, in the 6th year, what happens that a new election officer has been appointed and he says that he will abide by the constitution of the students, and he says that only 4 posts will be advertised now, and in that case what happens that students come and break his office and misbehave with the election officer, saying that how is it possible that you will only conduct elections for the 4 posts. Earlier, for the last 5 years, the practice was that 5 posts elections, those were held. So, what will be the situation? Now, the situation is that there is a constitution which is the legislation for the students, and the constitution has been made. So, if there will be a conflict between the practice might be of 5 years or maybe 10, 20 years or maybe more than 20 years, but if the election officer is going by the statute which is the students' constitution, then the action of the election officer will be sustainable even in the court of law, because the practice is in conflict with the statutory law. And therefore, this will be also an important test to understand the custom as a source of law. Unless and until practice will also not be matching with the statute, this will be not a source of law. Finally, the source of law will be also, the custom will be the source of law if it is recognized by the courts. Now, this you might be thinking that why is it necessary that custom must be recognized by the court? You see, because of the fact that it is the court which has to decide that whether this will be a source of law or not, and therefore, first of all, if a custom is recognized, then it will be very easy to advance the argument that this is a custom which has been recognized earlier by the court. But if that is not so, then you will have to first of all try to convince the court that this particular practice is a practice which is simply not a practice, but it has matured into a usage, and further it has matured into a custom. Then if the court is convinced and if the court recognizes that, it will become a source of law. So, you might be thinking that it is very difficult, these elements are there, you must not simply go and allege in the court that this is the custom and therefore, it is a source of law. Then we come to some of the customs in India. I am not talking about all the customs which are prevalent in our country. but some of those customs which are there, let us try to understand those. And on that basis, we will also understand that there are different types of custom in our country. First of all, we will try to understand the general custom. A custom can be general one. It means that it is spread all over the whole territory of the country. For example, amongst the Hindus of our country, when the marriage takes place, Saptapadi, 7 steps around the fire, that is considered to be a practice which is a customary practice, and now it has been recognized by the statute also. Hindu Marriage Act 1955, that also accepts this fact that Saptapadi is important as a ritual of marriage. Likewise, Sapinda relationship. Sapinda relationship is also recognized as the general custom which has been also statutorily recognized. So, Sapind means that if a person should not be from the same forefathers, foremothers, and they will marry each other. So, this Sapind relationship, avoiding this marriage between or amongst the Sapindas, that is also a general custom. Then there is also the possibility of a local custom, like in a particular locality the custom might be there. For example, in Andhra Pradesh there is a community called Kamma, and the Kamma community has a custom of affiliating a son-in-law, and what they do, that they give the son-in-law a share in property. Now, this is a different kind of practice. Normally, the son-in-laws are not given any share in the property of the bride side. This kind of adoption, they adopt the son-in-law, and this kind of adoption is called illatom adoption. So, this is a local custom. This is an example of local custom. Likewise, in South Malabar area, there is a class of people who are called Nayars, and they recognize polyandry. So, polyandry is not a normal practice, it is not a general practice, but it is a local practice which is prevalent in South Malabar and amongst the Nayars. They have also the practice of descent of property through females. So, this is normally the descent of property goes by the male lineage, but in the Nayar community the descent is from the female line. And there may be another example of local custom normally which was started from the Islamic era, and that is called the right of preemption. Preemption means that suppose if a person wants to sell his property, he will give right first of all to his near relatives. So, if the near relatives will try to buy or take something from the seller who happens to be a close relative, in that case the first preference should be given to the relatives, to the kins of the seller. So, this is called preemption. Now, this became a practice in the whole Islamic kingdom, but when there was Islamic rule in India, and then even afterwards British times also, this custom became prevalent in a locality. So, this is also an example of local custom. There can be a possibility of family custom. Family custom, the example can be that if a family has a practice, then that practice, wherever the family goes, this practice may be accepted. For example, Jats can adopt an orphan. Now, this is a practice which was not normally allowed as a practice, but the Jats had this kind of practice which was a family practice, because they had a problem that sometimes they did not have a son. In that case, orphans could be adopted. And there is also a family custom of impartibility of estates, and this is a family custom recognized in several families. Then there may be a possibility of religious custom, like Jain community. The practices of Jain may be that a widow can make an adoption without the consent of husband, except in Madras and Punjab, where such thing is not possible, but otherwise normally the Jains, in Jains a widow can make an adoption without the consent of husband. The power of the widow to alienate self acquired property of her husband is also considered as a religious custom. So, there are several examples of custom, and finally, we have the example of conventional custom. What is the meaning of conventional custom? You will think that custom which is found in the tradition, that is conventional custom. The answer is no. Conventional custom means that a custom, a practice which is coming from a business practice. In the business convention, there is a convention in the business. So, conventional practice means what is the practice on agreements, what is the practice on the sale or buying of something, and what is the practice on the bill of exchange, the checks, etc. So, this may be called conventional custom. So, agreement, it is mainly agreement based practice. So, making partnerships, etc., that is called conventional custom. Some of the selected customary practices of our country, just for the sake of interest, because normally nowadays students, they are not taking interest in custom as a source of law, because they just rely upon legislation, but I thought that no, let us have some sincerity in making custom as a source of law, an important source of law. Let us see that some of the selected customary practices, for example, in our country since the time immemorial, the good behavior is considered to be a good practice and a custom. Sadachar, sadachar and prayashchit. Sadachar meant right conduct and prayashchit meant penance. If there will be violation of sadachar, then there can be a possibility of penances or the punishments. In Islamic law, the customary practices are found in the hadith and in the urfs. So, there can be a possibility that you will say that in Islamic law also customary practices are there. Then you might have heard about the word rivaj. This rivaj is also a very important word, and many rivaj are there, like rivaj-e-aam, that is called the kind of, aam means normal people, general people, and the practice of the people will be called rivaj-e-aam or wajib-ul-arj. So, these are the two examples of the practices, the words which are used in our country, and this was recognized by the Britishers when they passed a regulation in 1822, in which they directed the officials to collect village administration papers and to know about those rivaj-e-aam. Also, we have some of the manuals which have been written, and those manuals have been prepared by the instructions of the government, the then British government, and you see that even after independence such manuals are normally updated. And so, manuals of customary laws are issued by the district administration, which are very important pieces of evidence when the matter is relating to custom. You see that there have been several instances in which government appointed a person that you collect the custom, or maybe that the government may be knowing that this person knows the customs of a particular region, and therefore, the government authorized the person to collect the customs and publish it. The government published the book. Likewise, so we have some examples like Santram Dogra's Code of Tribal Customs in Kashmir. We have William Rattigan's Customs of Punjab. Punjab is also a land of customs. You see, in Punjab, it was very difficult for the Britishers to rule unless they could have recognized the customs. So, Kashmir was also very big. In Kashmir also, the local practices were there. So, the government appointed Dogra and William Rattigan. So, these are important pieces of publications which might be relevant in establishing custom in the court of law. Likewise, in the Kumaon region of our country, earlier it was in Uttar Pradesh, but now it is also some portion in Uttar Pradesh. and some portion in Uttarakhand. In the Kumaon region also, Panna Lal's Hindu customary law in the Kumaon region, that is also considered a very important publication, and you can refer to it as a source of law. So, entries which are made in these books or in the district administration manuals or in the village administration papers which were published by the government, all these entries are the proof of an accepted custom. So, proof is very important. We need proof for custom also. So, it is important, and therefore, I will now tell you that our Indian Evidence Act 1872 and the Bharatiya Sakshya Adhiniyam of the last year 2023, how these will be helpful to make the court convinced that okay, this custom can be recognized. You see the section 35 of Indian Evidence Act, now it is 29, section 29 of Bharatiya Sakshya Adhiniyam, which says that relevance of entry in a public record which is made in the performance of a duty, now that is a piece of evidence. So, suppose if an entry is made in the public record, then under section 35 of earlier Indian Evidence Act or under section 29 of the current Bharatiya Sakshya Adhiniyam, this can be proved. You can say to the court, you can pray to the court that this practice is already entered in the public record, and therefore, the court should be accepting this custom. Then we have section 48 in the erstwhile Indian Evidence Act, and now this has been incorporated in section 42 of Bharatiya Sakshya Adhiniyam, which says that if there has to be an opinion, the court has to form an opinion whether there is an existence of custom or not. Now, how will that be done? The Evidence Act says that the person who would likely know about the existence of that custom, that person should be there, that person's statement can be admitted by the court. So, section 48 is also very important, where the court can take opinion of the persons who are likely to know about the existence of the custom. Then we have section 49 of the erstwhile Indian Evidence Act and section 43 of Bharatiya Sakshya Adhiniyam, in which if the court has to form an opinion as to uses or the tenets of a family, then what can happen? Then this provision says that a person who is having special means of knowledge about the custom, now that will be important. So, suppose if a person can be produced to the court who has the special means of knowledge about a custom of the family, then that statement can be accepted, and that statement will be helpful to recognize that practice as a source of law. Then we have section 56, and corresponding section in BNS is section 51, which says that facts which are judicially noticeable will not be needed to be proved. What does it mean? It means that suppose if a custom has been repeatedly recognized by the courts, then this has been already taken, this has been taken notice by the judiciary, and therefore, this will not be needed to be proved. So, it becomes very easy. Suppose if the courts have recognized a particular custom, it will be easy for you as a lawyer in future to establish that custom in the court in the same jurisdiction. Finally, section 57 and the corresponding section of BNS is section 52, which says that facts which are written in a book or a document may also be judicially noticeable. That means that section 35 as well as section 57 of the Indian Evidence Act, that will help you. Suppose if you give the evidence of Panna Lal's or Sant Ram Dogra's book, that will be an important piece of evidence, because that there is a fact which is written in a book or the document, therefore, it must be judicially noticeable. So, I hope that you must now have a fair idea of custom as a source of law. because unless and until you will not prove these steps to prove the practice as a custom, custom will not be recognized as a source of law. The judiciary must recognize, and until and unless the judiciary will not recognize, it will not be custom, because ultimately the courts have to implement the custom if the parties have come there. But otherwise, if you are not going to the court, then if you want to enforce the custom, it is upon the popular wishes. If the popular will is there, there is no problem. But if there is a dispute, and when you have to go to the court to resolve the dispute, and then when you allege custom as a source of law, you will have to go through all these steps. Now, we will also look at another source of law, which is legislation. Legislation is an important source of law in the modern times. In the current times, legislation, it would not, if it would not have been there, then perhaps for the lawyers, the fee of the lawyers would have been even higher, because they will have to always prove from the different books and from the practices of the people. But now legislation removes that hurdle. The legislation is very important as it is easy to understand. The sections are systematically analyzed, the provisions are having a particular science, and therefore legislation has become the craze in the last more than 100, 150, or even in the last 200 years. Legislation is gradually replacing the custom as the first source of law. Earlier it was the custom which was the first source of law, but now legislation is gradually going to be the paramount source of law. It is like a ready cash. You have the cash and you can do whatever you like to do. You have the cash, you want to buy something, you want to take your food, you want to buy your food, just have your cash, you give the cash and you will get the food. It is like that. Law is, if it is there, if the legislation is there, then it is very easy that you can just have the bare act with you. And now after the advent of computers, laptops, tabs, etc., everything is on your tab, everything is on your laptop. So the legislation, you can save it on your laptop, and the legislation need not to be proved in the court. So how easy it would be. Now the students have to remember the legislation provisions. Now what are the provisions in a particular legislation? Because once they know that, they understand that, then it will be easy for them to tell the court that, look, your lordship, this is the law, this is the section, this is the article, and therefore this will be recognized by the courts also. Once you understand the importance of legislation as a source of law, let us also try to understand the different types of legislation. There are basic different types of legislation, and the two main types of legislation are called, one is supreme legislation and the second is called subordinate legislation. The supreme legislation means that it is not that there is a kind of hierarchy of legislation, but supreme legislation means that a law which has been passed by the supreme legislator. For example, in our country, the supreme legislator is the Union Parliament, and therefore if Union Parliament passes a law, then that is the example of supreme legislation. The next example of legislation is called subordinate legislation. Now subordinate legislation means that a law which has been passed not by the supreme legislator, but by the subordinate legislators. So can there be the example of the state legislatures passing a law as an example of subordinate legislation? The answer is no, because we have the constitutional scheme, and in the constitutional scheme the states are also given powers within their jurisdiction, and those powers, within that sphere no one can encroach upon. And therefore the example of supreme legislation can be even the laws made by the supreme legislature of the state. So take for example, if Uttar Pradesh or if Punjab, if there has to be a law passed by the state legislature in the area of the state, then that is the example of supreme legislation. However, subordinate legislation is also another type of legislation where you will have some examples like the autonomous legislation. There are many autonomous bodies like the universities, like railways, and these are the autonomous bodies, and you know what, that these autonomous bodies are given the power to make laws, to make rules, to regulate themselves. So, this rule making power which is given by the supreme legislation or by the supreme legislator to the subordinate legislator, that is also important to understand, because normally if you have the misunderstanding that the example of legislation are only the laws passed by union parliament or the state legislature, that is not the correct position. The correct position is that even the rules, the regulations, the ordinances which are passed by the autonomous bodies or sometimes by the executive is also empowered to frame rules and to make regulations, to issue orders. And the question is whether this order is an example of legislation. The answer is yes. Even the order is the example of legislation. So, executive orders, because the supreme legislator has authorized the executive, the officer concerned, to issue the order, and therefore, that order is also an example of legislation. That may be a law, that is the source of law. You can say that this is the order which is issued by the person who is authorized to issue that order. If a person is not authorized to issue the order, then that will not be legislation. So, another subcategory is that of delegated legislation. When the supreme legislator has delegated the powers to some executive, some authority or some other bodies to make a rule, that is called delegated legislation, and in pursuance of that, if the rules are made, that is the example of the delegated legislation. So, delegated legislation is also legislation. It is not that suppose if the executive will frame rules, this will not be legislation. So, this is also legislation which is a source of law. Then we must also try to understand the technique of framing the legislation and how to understand the bare acts and the statutes, the provisions of the statutes, because there is the source of law. In the legislation itself, in the inner portion of the legislation, you will find the exact law which is a source. So, how to understand legislation, that is also important, as we all want to know about the Indian legal system. So, if you look at any of the act, take for example, Indian Contract Act. Now, this is an act. Now, legislation means that there will be an act, enactment. Act is derived from enactment. So, act is enacted by the legislator, supreme legislator, it means union parliament has enacted a particular act. So, take for example, Indian Contract Act. Now, the union parliament that had enacted the Indian Contract Act. So, this is what we call the enactment of an act. So, this enactment is finally given the word act, Indian Contract Act. We can also give the legislation a title which may be code. For example, Indian Penal Code. Now, why is it called? This is also a piece of legislation, but this is called a code, because this was one of the first instances in which the laws relating to penal laws, the area where crimes happen, all those rules were accumulated by the Britishers at that moment of time, and therefore, it is called code, or in Hindi we call it Sanghita. So, Sanghita is also codification, like we have now Bharatiya Nyay Sanghita. So, this is example of code. Do not confuse it with, you say that no, code is not piece of legislation. Code is also a piece of legislation. And the Constitution of India, where you will find that there is no mention of an act, but there also you can find that this is the example of the highest law of the land. So, this is about the whole country, the Constitution of India. And after once you understand all these things, then it comes that how to understand the different provisions of the legislation. For example, you will find Indian Contract Act. Now, this is the short title of this legislation, and what is the long title? You will go inside the bare act, and the first line normally of the act, that will be called the long title, an act to do something, an act to amend the earlier existing law, an act to consolidate the laws. This will be the normal language of the long title. Likewise, you can find sections, you will find subsections in the legislation. So, there will be section, this section deals with culpable homicide, this section deals with murder, and then within it there will be subsection. This is all science, this is all expression of a legislation, how the legislation is arranged, the arrangement. There will be clauses, there will be sub clauses, there can be exceptions, and every word of a legislation, that is important, because when legislation is given final shape, it is very, very difficult for the drafters. You might be astonished to know that the drafting takes long time. The drafting of a legislation is very difficult. You need to have the skill of drafting, and therefore, the Parliament of India, they have a lot of people who are involved in the drafting of any laws. Then in the legislation you will find marginal notes. In the left side of the section you will find notes that okay, this section will deal with suppose culpable homicide. So, 299 earlier 299, and in the left side you will find it is written culpable homicide. This is called marginal note. And then you will find that there is also something which is hidden, you might not have noticed, like you will find that Indian Contract Act number, this number of 1872. Now, what is this? It means that is the official citation. This means that this enactment was made in 1872, and which number of the enactment, what was the number of that year. So, suppose in a particular year X, if the number of a number of legislation is A, then A will be the first digit, that number A of year X, like that. So, the whole system is arranged in this way. This is the beauty of legislation, and therefore, legislation is a main source of law. So, with this I hope that you have understood the two main sources of law. The first was custom as a source of law, and the second was legislation as a source of law. Both these sources are very important, but if you have to compare these two different sources of law, legislation will be definitely holding a higher ground today, because it is very easy to know the legislation, to understand the legislation, but as you have seen that it is very difficult to prove a custom in the court of law, and unless you will not prove it, if there is a dispute which has gone to the court of law, then it will be very difficult for you as a lawyer. But you do not have to worry, you must have known that what are the essential steps, so that a practice can be proved into the court of law. I have told you about the provisions of Indian Evidence Act, Bharatiya Sakshya Adhiniyam, which can help you in proving the custom in the court of law also. So, I hope that you must have understood all the various facets and aspects of custom and legislation. Legislation, I could not tell you a lot of other things, but I hope that the things that we discussed today those will be very helpful in understanding both these sources of law. Thank you so much.
Many a times we all think, who am I? Why am I doing whatever I am doing? Why do I feel attracted towards others? Why do I feel very aggressive in certain instances? Why certain people or certain type of acts, they repel me? Why is it that I always search for certain things which look very, very ambiguous? These are the things, these are the questions that all of us experience, all human beings. And you would realize that many a times certain domains of knowledge, especially within social sciences and all sciences at large, when you look at it from a philosophical point of view, they would try to give you the answers to these questions. Now, one of the branches of understanding which helps you understand things much better, which also helps you understand not only what is visibly present before you, what is glaringly apparent to you, rather which also tells you what is not visible at all, what goes within. Okay. And this is the subject knowledge, what is called as psychology. It is not only that it helps you understand the manifested behavior, the overt behavior, how you talk, how you speak, how you say it, how you interact, how you respond, not only that, but also what goes within, what makes you do this, what makes you think this way, what makes you act that way. Why is it that certain things you appreciate, certain things you feel attracted towards, and why is it that many a times in certain type of situations you feel you should completely go out of it, you should not get anyway involved into it, the repulsion. Why is it that certain acts, although you do not appreciate, still you get involved into it? Then you reinterpret your own behavior and you start giving birth to certain type of experiences, shame, guilt, pleasure, appreciation. You see world in a particular way, you analyze it in a particular way, you derive emotion out of it, feeling out of it, and the mix of what you perceived along with what you experience, it makes you act in a particular way, respond in a particular way. Your response is received by somebody else, and then the other person also responds in that situation. Now, there are situations where several people interact simultaneously. The situation remains constant and different people interact at the same time. You realize that your identity gets lost. You are not an individual. You act what is called as group behavior. You realize that you do not have an explanation for either favoring somebody or completely being unfavorable to the other person. You later on realize that it was a favorable or an unfavorable attitude towards that individual. You realize that you repeat certain form of behavior. Why? You do not know. People tell you that such type of repetitions are not normal. Human beings largely do not do that. And then you realize that okay, this is a particular pattern of a behavior for which I require the help of a specialist. The specialist tells me that this pattern of behavior is given a particular taxonomy, a particular nomenclature, which is either some aberration in the normal behavior, it is a neurotic form of a behavior, psychotic form of a behavior, it could be a psychosomatic response. And psychology, it covers all of this. So, if you want to understand yourself, if you want to understand others, this is the subject which helps you achieve that target. It is behavioral sciences that makes you understand human beings, human responses, human existence in complete totality.